Good day, sir. I am J.N. Legaspi Itol.
And I am Mark Pirater.
And this is our report. Police Systems, Differences between Canada and Central African Republic. Concept of police. The police are a constituted body of persons empowered by a state with the aim to enforce the law, to ensure the safety, health, and possessions of citizens, and to prevent crime and civil disorder. Their lawful powers include arrest and the use of force legitimized by the state via the monopoly on violence. The term is most commonly associated with the police forces of a sovereign state that are authorized to exercise the police power of the state within a defined legal or territorial area of responsibility. Police forces are often defined as being separate from the military and other organizations involved in the defense of the state against foreign aggressors. Police forces are usually public sectors of services funded through taxes.
History of Police Central African Republic. The National Police was established in 1963 with 315 employees, not long after the Central African Republic gained independence from France. At the period, there weren't many crimes using firearms in the nation. Therefore, the police had few weapons and mainly worked unarmed.
Law Enforcement Agency for Organized and Terrorist Group in Canada. In order to assist in the identification, prevention, and deterrence of money laundering and the financing of terrorist activities in Canada and abroad, FINTRAC is an independent arm's-length agency of the Canadian government that gathers, analyzes, assesses, and discloses information to the law enforcement community and others. FINTRAC has been crucial to the national agenda and a significant partner for the NCC by providing financial intelligence and assuring compliance. The federal, provincial, and territorial or the FPT governments are still collaborating to develop solutions for this ubiquitous issue. This steadfast dedication to cooperating is shown in our continuing efforts to collaborate with one another and the legal system and other relevant partners. The National Coordinating Committee on Organized Crime or the NCC and FPT organization is an important part of these operations.
Law Enforcement Agency for Organized and Terrorist Group, Central African Republic. In the prefectures of Mubo and Haute-Kouto and the Union for Peace is the Central African Republic UPC and the Front Populaire for La Renaissance in Centrafrique have been responsible for numerous grave human rights violations, including sexual violence, particularly rape and sexual slavery, mostly of girls between the age of 11 to 17. Russian allies and the FACA had allegedly provided support and backing to the anti-Balaka.
Comparative police system. Letter A, the application requirement. In Canada, first, permanent resident applicants need to have resided in Canada for the last 10 years, be at least 19 years old, possess a valid and restricted driver's license, be able to spend 26 weeks at the RCMP Academy in Regina, Saskatchewan, be a Canadian citizen or a permanent resident of Canada. Be proficient in the English and or French languages. Have a Canadian high school diploma or equivalent. Be in good health. Meet the vision standards. Meet the hearing standards. Meet the necessary level of physical activities. Have a good character and have no criminal convictions and no criminal charges pending.
Central African Republic. Security sector reform, a prerequisite for establishing the whole of the Central African Republic, has been boosted by the recruitment of over 1,000 new officers to the country's internal security forces. Students must undergo several months of technical professional training in public security, law enforcement, police administration, judicial, and forensic procedures, as well as in ethics and deontology. At least 18 years old but under the age of 30 years old, must have a valid driver's license, must not have criminal record, must be fluent in English at least one other official language.
Next is the organizational structure in Canada. Municipal, provincial, and federal police services are available in Canada. As a combined international, federal, provincial, and municipal policing organization, the Royal Canadian Mounted Police or the RCMP, Canada's National Police Force, is exceptional in the world. The RCMP is currently divided into 4 regions: the Atlantic, Central, Northwest, and Pacific. 15 divisions for one each province and territory, the Training Academy in Regina and the National Capital Region, and has its headquarters in Ottawa, Ontario. Divisions roughly approximate provincial boundaries with the respective provincial or territorial capitals serving as the division's headquarters.
Central African Republic. The paramilitary Central African Gendarmerie and the Central African National Police, also known as Sûreté Nationale, are primarily responsible for maintaining order in the Central African Republic. The National Police is a uniform civilian branch that focuses almost exclusive on maintaining order in urban areas. The National Police Criminal Investigate Branch is a third department known as Police Judiciary, although it has grown more autonomous and now largely regarded as a distinct branch in its own right. Since the Central African Empire's dissolution, the National Police has generally maintained a staff of between 1,000 and 2,000 officers. The nation's police force numbered 1,350 in 2009. The Central African Republic effectively has 2 national police forces that are modeled after French law enforcement.
Power and function in Canada. Patrol assigned areas to maintain public safety and order and to enforce laws and regulations. Investigate crimes and accidents, execute search warrants, secure evidence, interview witnesses, compile notes and reports, and provide testimony in courts of law. Apprehend the arrest criminal suspects, provide emergency assistance to victims of accidents, crimes, and natural disasters. Participate in crime prevention, public information, and safety programs. And last, may supervise and coordinate the work of other police officers.
Central African Republic, the National Police, formerly known as the Sûreté Nationale, is a uniform police division with its headquarters in Banjul and is tasked with upholding civil public safety regulations in significant urban areas. The National Police is run by a centralized direction service, the Service de Sûreté Nationale, and is, as its name implies, organized on a national rather than a municipal level. The police have been mostly restricted to Banjul proper due to a lack of funding and manpower. Outside of the capital, their influence is largely insignificant.
Ranks and classification in Canada. Pursuant to the Regulation 929 RRO 1990, the Toronto Police Service will have all or any of the following police ranks in the following order but no other. First is the Chief of Police. Second is the Deputy Chief of Police. Third is the Staff Superintendent. Fourth, the Superintendent. Next is the Staff Inspector, Staff Sergeant and Detective Sergeant, and Sergeant and Detective, and the last one is the Constable.
Central African Republic. The military ranks of Central African Republic are the military insignia used by the Central African Armed Forces. Being a landlocked country, the Central African Republic does not have a navy. Being a former colony of France, Central African Republic shares a rank structure similar to that of France. General de Army, General de Corps de Army, General de Division, General de Brigade, Colonel, Lieutenant Colonel, Commandant, Kapitan, Kapitan, Lieutenant, Sus-Lieutenant.
Next is the comparative criminal justice. So first in Canada. The Canadian criminal justice system is comprised of three major components, which are the police, courts, and the correction services, each of which includes several types of official decision makers. At that point, charges may be laid, an offender arrested without warrant, or alternative measures invoked. If none of these steps are taken, the offender appears at a judicial interim, release hearing, and eventually the trial court, youth or adult. A plea is entered and the trial begins, during which the prosecution must prove beyond a reasonable doubt that the accused actually committed the crime. The jury or judge makes a decision regarding the accused guilt or innocence, and its guilt determines the appropriate disposition of the case. Options include discharge, fine, forfeitures of proceeds, provision order, suspended sentence, compensation to victim, community service, or other custody or treatment.
Central African Republic. To deal with the organized crime, the CAR's judicial system is powerless. Pre-trial detention accounts for a sizable portion of the CAR's overall jail population. But since the Special Criminal Court was established in 2015, some militiamen have received the prison sentence in Bangui, and more charges are still pending. Additionally, there is a national strategy for the demilitarization of prisons, which was authorized in 2019 and developed with the help of a number of foreign actors. In the same way, the CAR's law enforcement organizations are powerless to stop organized crime. Although law enforcement agencies are being rebuilt with the support of several foreign partners, corruption remains a major problem, especially in the customs service. As for territorial integrity, the CAR's border presents a unique case of porosity with the total absence of any border control. The only functioning border posts are located between the CAR and Cameroon.
Comparative court justice. First in Canada. The Canadian court system, formerly known as the King on the Bench, constitutes the country's judiciary, which interprets the law. It is made up of numerous courts with varying degrees of legal expertise and is divided into jurisdictions. While some of the courts have a federal focus, others are territorial or provincial. According to the Canadian Constitution, the provinces have exclusive authority over the majority of civil law, while the federal government has exclusive authority to enact criminal law. The administration of justice inside each province's borders is under their control. Almost all matters, whether they are civil or criminal, are heard in courts that have been formed by a province or territory. Only issues involving subjects under solely federal control, such as federal taxation, federal administrative agencies, intellectual property, some areas of competition, law, and specific facets of national security, are heard by relatively tiny systems of federal courts. Along with provincial and territorial courts, the federal courts also have authority over civil lawsuits brought against the federal government.
Central African Republic. A new court in the Central African Republic's court system, the Special Criminal Court, has for the purpose of trying serious international crimes committed during the nation's conflict since 2003. The Central African Republic established the Special Criminal Court in Bangui. The court has 5-year term that may be extended only once for a total of 10 years to investigate and prosecute grave violations of human rights and international humanitarian law committed on the territory of the Central African Republic since January 1, 2003, particularly the crimes of genocide, crimes against humanity, and war crimes. He power to prosecute serious crimes committed during the nation's armed conflict since 2003.
Comparative correctional system. First in Canada. The Canadian correctional system provides three main types of penalties. First is the payment of fines and victim compensation. Second is the social medical obligations such as voluntary or compulsory treatment and provision under certain conditions. And last is the imprisonment. The country's criminal code is unified across all 10 provinces. Amendments to the code are voted on by the federal parliament, but infractions and regulations come under the jurisdiction of provincial governments and municipal authorities. Operational norms applicable in the case of adult offenders also hold true in centers and special schools for juvenile delinquents.
Central African Republic prisons typically suffer from extreme overcrowding, lack of food, absence of adequate medical care, and poor sanitation. It is essential when building lasting peace and security to have functioning and accountable judiciary and to ensure prisons are not forgotten. Rooted in MINUSCA's mandate, Article 33A of RIS 222-17-2015 and in Memorandum of Understanding signed on 5/7 August 2014 in the transitional authorities of the Central African Republic. The Justice and Corrections section carries out the following activities to support the transitional authorities to rebuild the country's justice and correctional institutions.
Next is the comparative juvenile justice system. So first in Canada, the federal law that oversees Canada's juvenile justice system is known as the Youth Criminal Justice Act or the YCJA. It implies to young people who run afoul of the law between the ages of 12 and 17. The YCJA acknowledges that although not in the same way or to the same extent as adults, young people must be held accountable for illegal activities. Making sure that as many juvenile offenders as possible receive rehabilitation and join society as contributing members is in the best interest of society. The YCJA is aware that children and teenagers lack the maturity of adults. The juvenile justice system has policies that are appropriate for this lower level of maturity. The YCJA also recognizes that young people have special needs and circumstances that must be considered when any decision is made under the Act. Although the juvenile and adult criminal justice systems share many parts of criminal procedure, the YCJA sets special procedures to guarantee that children are handled properly and to support their rehabilitation. For instance, publication limitations on their identities typically safeguard the privacy of young offenders, young victims, and young witnesses. According to the YCJA, young people must be held accountable in ways that are just and proportionate to how serious their offense were.
Central African Republic. The peace agreement signed by the government of the Central African Republic and other parties to the conflict is a welcome step towards lasting peace and the hope of a better future for the country's children. There are concrete steps that can help translate the peace agreement into meaningful action for the children. All parties to the conflict should take steps to release any and all children associated with armed groups. The judicial system should treat children arrested or detained due to their association with the armed groups as children and victims first and should ensure that their rights are upheld. The government should accelerate the process of adopting the Child Protection Code and align the country's juvenile justice system with international standards. UNICEF stands ready to support national efforts to help children affected by the conflict and is hopeful that agreement will be a fundamental step towards long-lasting peace for the country's children.
So next is the international criminal justice. So first, we will define the international criminal justice. In the area of international law, known as international criminal justice, the most serious war crimes and human rights violations must be prosecuted by those who planned and executed them. It is a component of an expanding body of international law that aims to put the person at its center, both as the perpetrator who must be held accountable and as the victim who has a right to redress. In doing so, it challenges the more sovereignty-centered international law established at the birth of the modern state system in 17th century Europe, in which only states have rights and responsibilities and national leaders are shielded from international accountability through the principle of non-interference, which exempts a state's treatment of its own citizens from international law and by conferring personal immunity to heads of state and diplomats and functional immunity to public officials. So in Canada and the International Criminal Court. The International Criminal Court, or the ICC, is an independent, permanent court of last resort with the jurisdiction to investigate and prosecute the most serious crimes of international concern, namely genocide, crimes against humanity, war crimes, and aggressions. Canada and the movement for the ICC. Canada played a pivotal role to establish the International Criminal Court and contributed to its development in a variety of important ways. Crimes Against Humanity and War Crimes Act. Canada became the first country in the world to incorporate the obligations of the Rome Statute into its national laws when it adopted the Crimes Against Humanity and War Crimes Act. Canada and the movement for the ICC. Canada played a crucial role in establishing the International Criminal Court. The ICC initiative was facilitated by an earlier draft statute prepared by the International Law Commission, began after World War II and finally adopted in 1996, and was galvanized by the reports of atrocities committed during the civil wars in Rwanda and the former Yugoslavia. Canada supported the ICC effort in the 1990s and continues to support the ICC with crucial leadership, advocacy, and resources. Canada played a pivotal role in establishing the International Criminal Court and contributed to its development in a variety of important ways, which include chairing a coalition of states called the Like-Minded Group that helped to motivate the wider international community to adopt the Rome Statute, generating support for an independent and effective ICC through public statements and extensive lobbying, contribution to a United Nations Trust Fund that enabled lesser developed countries to participate in ICC negotiations, thereby ensuring through international representation, helping to fund non-governmental organizations or the NGOs from developing nations so that the ICC process would benefit from their unique perspectives. Canada, ICC's leadership at home. On December 18, 1998, Canada was the 14th country to sign the Rome Statute. On January 29, 2000, Canada enacted the Crimes Against Humanity and War Crimes Act, becoming the first country in the world to adopt the comprehensive legislation implementing the Rome Statute. And on July 7, 2000, Canada ratified the Rome Statute. Lloyd Axworthy, the former Minister of Foreign Affairs, deposited Canada's instrument of ratification at United Nations headquarters in New York.
African Republic. CAR ratified the Rome Statute on 3 October 2001 and referred to the situation in its territory since July 1, 2002. The ICC therefore may exercise its jurisdiction over crime listed in the Rome Statute committed on the territory of CAR or by its nationals from July 1, 2002 onward. The ICC's investigation in CAR 1 focused on alleged war crime and crimes against humanity committed in the context of a conflict in CAR since July 1, 2002, with the peak of violence in 2002 and 2003. See CAR for the situation in CAR from 2012 onward. In opening the investigation in May 2007, the Office of the Prosecutor issued a press release stating, based on preliminary analysis of alleged crimes, the peak of violence and criminality occurred in 2002 and 2003. Civilians were killed and raped, and homes and stores were looted. The alleged crimes occurred in the context of an armed conflict between the government and rebel forces. This is the first time the prosecutor is opening an investigation in which allegations of sexual crimes far outnumber alleged killings. Hundreds of rape victims have come forward to tell their stories recounting crimes with particular cruelty. Reports detailing their accounts were ultimately provided to the prosecutor's office. Victims described being raped in public, being attacked by multiple perpetrators, being raped in the presence of family members, and being abused other ways. If they resisted their attacks, many of the victims were subsequently shown by the
notable organized terrorist crime group. So in Canada, we choose one, which is the Abu Nidal Organization, or the ANO. The Abu Nidal Organization is the most common name for the Palestinian and nationalist militant group Fatah. The Revolutionary Council, Fatah al-Majlis al-Thawri, the ANO is named after its founder Abu Nidal. It was created by a split from Yasser Arafat's Fatah faction of the PLO in the 1974. The group has been designated as a terrorist organization by the United States, the United Kingdom, Japan, Israel, Canada, and the European Union. The ANO was secular and anti-Western but was not particularly associated with any ideology, or at least no such foundation was communicated. The organization was strongly linked with Abu Nidal's personal agenda. The group carried out hijackings, assassinations, and kidnappings of diplomats and attacks on synagogues, 90 attacks during the period 1974-1992. Nidal died in Baghdad in 2002. Where does the group now operate? So the organization is largely considered inactive. In 1999, Egypt and Libya closed down ANO offices in their countries. Current and former leaders and associates are now thought to be in Iraq, with cells in Palestinian refugee camps in Lebanon.
The prefectures of Momo and Haute-Kouto, the Union Peace in the Central African Republic, and the Front Populaire pour la Renaissance in the Centrafrique have been responsible for numerous grave human rights violations, including sexual violence, particularly rape and sexual slavery, mostly of girls between the age of 11 to 17. Muhammad Saleh, an FPRC leader based in Nazako, has been implicated in several cases of rape and other serious human rights abuses. Agbit said, calling on armed groups to lay down their arms in the best interest of Central African population.